Hello, hello, and welcome to Crime and Court. My name is Heather, and this is part 4 of the transcript reading from the hearing for the motion for contempt that Nicholas McLeland, the prosecutor in the DELPHI case, has filed against the attorneys of Richard Allen. So we are now on part 4. If you missed the others, all the links are down below in the description of this video so you don't miss out. And then you will know, if you go in order, you won't be confused. All right, so we are going to read, like I said, this is part 4. So we have, let me open up my bookmarks here. We are in the defense's case now. So David Hennessy, the attorney for Allen's attorneys, he now has the stand, basically. Like, he is bringing people to, he's calling people to the stand to ask questions. So it's his case in chief, I guess, in front of the judge, even though it's just a hearing. But, so we have quite a few people, and we're going to have, Julie Melvin, Stephen Mullin, Lieutenant Holeman. So Mullin and Holeman are recalled. They're going to be called by the defense again. And then we also have Bradley Rozzi, who is one of the attorneys who is in question here. So let's dive in. First, hit that like button. Don't forget to subscribe. And also, just thank you. Thank you for being here. I appreciate you. All right, so we're going to start with the direct examination of Julie Melvin. Questions by Mr. Hennessy. Please state your name, or state and spell your name. Julie Melvin, and she spells it. Do you know a Terry Williams? Hold on, I'm going to make this a little bit bigger. That good. That's much better. Okay. Just want to make sure you guys can read it, because I know if I'm like on my phone watching YouTube videos, I can't see other people's screens very well, so I gotta blow it up. All right. Well, let's get started. So, do you know Terry Williams? Yes. What? This kind of cracks me up, all the whats. And what'd you say? Huh? I feel so bad for the guy, because I am hard of hearing. So I think there was audio issues during the day where a lot of people were having issues hearing one another, but Hennessy seemed to have had the most issues, and I was told that he was hard of hearing. I don't know if that's true or not, but all right. So, do you know a Terry Williams? Yes. What? Yes. How do you know her? I met her through this case. I'm going to hand you what's been marked as a defendant's L and ask you to identify it. Yes. What is it? That's my phone record of phone calls that we had back in 2017. With Terry Williams? Yes. And then Mr. Hennessy says, oh, move to admit L, defendant's exhibit L offered. Mr. McLeland says, Judge, I'm going to object. Whoops, I'm a little off center here. Judge, I'm going to object. I don't know what the relevance to this exhibit is. Phone records between Julie Melvin and a Terry Williams. I'm not sure the relevance to this proceeding, Judge, so the state objects. Court says, how is it relevant? And Mr. Hennessy says, well, the next sheet is a Facebook page, a shot of a Facebook page of Terry Williams, and it involves Terry Williams sharing with Ms. Melvin confidential information about the investigation and from whom she received it. These are the other leaks, and the relevance, again, is to show that there's plenty of other sources not connected to, I'll tell you, I don't think the Westerman leak, Westerman's been contacted or connected to Andy by the evidence, but no evidence of the leak, and so I'm asking to put in evidence of other leaks so that on the issue of contempt, that there's many other sources of information about the investigation, as the evidence goes on, there will be testimony that even the photos that they attribute to Mr. Westerman the photos that they attribute to Mr. Westerman cannot have come from Mr. Baldwin's office. The court says, and do you have this Terry Williams here to testify? No. Oh, well, then I'd have to sustain the objection. What? He says, okay, show L offered, please. I'm sorry? You're showing L as offered. It's in the record, correct? It's marked, yes. Mr. Hennessy says, okay, and you give it to Jody? Very good. All right, so can you identify then Exhibit M? Yes. What is it? It's basically the accounting that Terry Williams gave to me on the phone, but it's written as she told it. Was that Facebook post? Yes, by Terry. Offer M. Defendants M. Offered. McLeland. Judge, I object on hearsay and also relevance. I guess I'm not sure of Mr. Hennessy's plan, but if his plan is to parade a bunch of podcasters and YouTubers on the stand and talk about their leaks, that has no relevance in what we're here to discuss today, Judge. How is it not relevant? It's exactly the same thing that Andy Baldwin is accused to have been doing. But he's not. He's trying to defend himself by saying, hey, there's these other sources of leaks. So you can't possibly say that it was absolutely Andrew Baldwin was the source, especially if these other photos aren't even in the possession of the defense. It makes no sense. So it's absolutely relevant. All right, we're here to discuss the information the state outlined in the contemptuous information filed with the court. The fact that the defense, believes there are other leaks, or podcasters believe there are other leaks, or YouTubers believe there are other leaks, has no relevance. It's not that they believe there's other leaks, it's that there are other leaks and they're trying to prove it, but you're not letting them put in the evidence. All right, so Judge, and so on those two objections, the state is going to the state is objecting to the admission of those pieces of evidence, and Mr. Hennessy says, well, number one, the court says, go ahead. Number one, it won't be a parade because I'm going to call them one at a time. Number two, it's highly relevant, at least in my mind. It goes to the theory of the defense. Oh, and I've already explained why it's relevant to both the punishment and contempt. Okay? I think at some point, if you get to the question of punishment, organizational math, and what kind of damage or prejudice or harm that has that cause versus leaks about the complete probable cause affidavit, the existence of a bullet at the crime scene, the recovery of the firearm at Mr. Allen's house, and it goes on and on. So the leaks of these photos they may be prejudicial, but it's not as bad as what you guys had in the probable cause affidavit that got leaked somehow. We're not saying you did it, but it looks like you did it. And that has very prejudicial evidence, including where, the bullet at the crime scene that they're claiming seems to be Allen's, which makes no sense because the girls weren't even shot. So why would there be a bullet? The recovery of a firearm at Allen's house. Again, the girls weren't shot that we know of. It doesn't seem, and the casing was apparently unspent, so that means it didn't go boom. So I don't know how they're relating it, but whatever, that's what they say is their one and only piece of evidence to Richard Allen. And that's not going to stand up in court. And it goes on and on. All right, so the court says, all right, I'll sustain the objection to M. She is such a bitch. Again, don't tell me there's no bias. Don't tell me there's no bias. All right, continuing on. Sorry, I'm trying to drink my morning coffee and talk to you guys at the same time. It's hard. Question. Have you followed the DELPHI case? Pardon? Have you followed... See, even the witnesses can't hear the questions. Have you followed the DELPHI case? Yes. Did you grow up in Delphi? No. What county do you live in now? I live in Hamilton County. And have you seen postings of other evidence from the investigation? Mr. McLeland says, objection, judge, again, relevance. I don't know what this has to do with the allegations outlined in the state's information. Mr. Hennessy says, well, if he can't understand it, doesn't mean it's not admissible. The court says, that's uncalled for, sir. And I'm sorry? That is uncalled for. Evidence has to be relevant to be admissible, and this is not admissible evidence. It's not relevant. I'll sustain the objection. How can you say there's no bias here? Just look at how she's ruling. Come on, Supreme Court, do something about this. This is not okay. This makes me angry. All right, so Mr. Hennessy continues. Okay, I'll make an offer to prove, then I can, and I'll approach with both the case law and the rule if the court would like to have it. I can do that by question and answer, or I can do it in a summary fashion. Court says, summary fashion. I'm familiar with the case law and the rule, sir. Well, Lottie friggin' da, Ms. Gull. All right. Mr. Hennessy says, okay, Ms. Melvin would testify that she has followed this closely, that she has seen many other posts that has been publicly disseminated on purpose and willfully by other people that is evidence from the investigation, including crime scene photos unconnected to the defense, unconnected to Mr. Westerman, unconnected to Mr. Fortson, and that the sources have been vast, including law enforcement, Sergeant Holeman for one, and other people involved in the investigation. How's that not relevant? If law enforcement, including Sergeant Holeman, might be a source, the court says, and if any of that had to do with the charges that are being alleged by the state of Indiana, it would be relevant. Do you have any further questions of the witness? Wow. No, ma'am. Do you have any cross-exam? No, Your Honor. Thank you, ma'am. You may step down. Wow. I just can't even with this woman. Mr. Hennessy says, I will call Stephen Wood. He is sworn in, and this is the direct examination of Stephen Wood by Mr. Hennessy. Please state and spell your name. He says, I'm sorry. Please state and spell your name. Oh, it's Stephen Wood. He spells it out. Do you have a nickname? Online, yeah, Skip Jansen. People call you Skip? They do. And have you followed the DELPHI investigation? I have. I followed it since August of 2020. And do you know a Gary Baudette? Yes. How do you know him? He and I became friends. We initially met around, I think, January of 22. I made several appearances on his channel, YouTube channel, talking about the case, and we just became friends over that time. And were you a part of a group that he was a part of a group of? I'm sorry, what? Say it again. Were you a part of a group that he was a part of? Yes, we were in a Discord group. Do you know of different names that he went by? He went by Fig Solves. He went by Fig Newton USA, I think, on Reddit, but mostly, he's known as Fig. And Fig? Affirmative response. Is that one? Yes, Fig Solves, Fig Newton. Those are fun. Okay, I don't know the guy, but sounds fun. And I'm going to hand you what's been marked. This is like wet and it keeps getting my nose wet. Sorry. I'm going to hand you what's been marked as Exhibit N and ask if you can identify it. Yeah, this is a conversation he and I had over text. And how do you know that? I'm familiar with the conversation. He and I talked a lot. Like I said, we were good friends, so we communicated a lot. Offer N. Defendants offered N. Judge, may I ask a few foundational questions? Yes. Oh, now he's pulling Hennessy's trick. Mr. Wood, the conversation that you had with Mr. Baudette, does it have anything to do about an email sent from Mr. Baldwin to Mr. Woodhouse? It does not. Mr. McLeland says, does it have anything to do with the photos that were taken from Mr. Baldwin's office? I don't believe so. Does it have anything to do with the press release from the defense that was released in December of 2022? I can't recall. Mr. McLeland, does it sorry, I don't know why I keep saying his name. Does it have anything to do with an ongoing leak from the defense out to the public? From the defense, I mean, we talked about ongoing leaks. Mr. McLeland says, I meant this conversation here that you're trying to admit. Oh, no. Judge, then I object to the relevance of the hearing, to this hearing. Any response? No, I won't rehash. Okay, then I will show N as not admitted. So she doesn't even let them admit any of their exhibits. How is this woman being fair? I can't stand people like this. All right, so question, hand you defense exhibit O, can you identify that? Yeah, this is a text conversation between Fig, Gary Baudette, and myself, and it's covering several different things about the case, about sources in the case mainly. Thank you, offer. Mr. McLeland says, I guess can I take a look at it, please? See what it is. Judge, same objection as before, the relevance to what we're here to discuss today in court. So just same objection. Court says, any response? Same response. And I will show O is not admitted. You can even hear it in Hennessy. I know they're just words on a page, but how can you not feel the emotions behind these words? And somebody said I was putting emotions and things or attitude behind Judge Gull. And I'm going to, because this is my channel and I can't stand her because she's unbiased and unfair. And she is clearly ruling all in favor of the state. And she's denied almost every single thing from the defense except maybe 5 things. If we're keeping track, we had 5 wins so far for the defense where they've had an objection that was sustained. And in the grand scheme of things, it doesn't even matter because all of this stuff is happening and whatever. Yeah, it's like she did those 5 just to throw them a bone or something. And to make it appear that she's not biased. Because, oh, look, I've ruled in their favor 5 times in this hearing. No. Anyways, any response? No, same. Okay, not admitted. Okay, I'm going to hand you an envelope marked flash drive Fig November 22nd, 2022 YouTube video. Are you familiar with that? I am familiar with the video, yes. And inside is a flash drive of that YouTube. And you recognize that? I do. And what does he talk? Oops. What'd you do in that YouTube? What? What about in that YouTube? Okay. He talks about cartridges, bullets, casings, unspent casings, cartridges, mostly evidentiary stuff for the most part. Move to offer Q. Court says Q. McLeland says, Judge, I'm going to object. Same objection, relevance. I don't know what it has to do with the information outlined in the filing of the state. Mr. Hennessy says, same response. Court says, all right, I'll show Q is not admitted. All right. They can't even put up their defense. She's not letting them defend themselves by showing that there have been other leaks. And that you can't possibly pinpoint the leak solely to Andrew Baldwin, who still would have had to have intentfully and willfully, maliciously leaked the items, and that still hasn't been proven. All right, so the court says, all right, it's not admitted. And then Mr. Baudette did Mr. Baudette reveal a lot of detailed information about the investigation? Mr. McLeland says, objection, Judge, same objection. I'm not sure that's relevant to what we're here to discuss today. Sustained. Mr. Hennessy says, it's the same relevance. It's the same, my theory and theme regarding contempt and punishment. There's 2 parts to it. The court says, you need to give that exhibit to Jody if you want it in the record, sir. She has it. Oh, you've got it? Okay. Do you have any further questions? for this witness. Offer to prove. Go ahead. I'd like to do it in question and answer form. It'll be brief. That's the preference under the rule. You may proceed. Thank you. Could you please, just for the record, indicate what kind of information Baudette was putting out there? Are you specifically to the October, November of 2022, or just in general? All over. A lot of stuff. So he claimed to have different sources, and he talked about a lot of things. Just, wouldn't he indicate that there was going to be a release of documents in 1 week, and then that occurred within 1 week? Yeah, he did. On, I believe, June 16th of 2023, he said that his source had told him they were going to release a large set of documents. Some are older, some new is how he described it, and then a week or so later they were released. Did he post that he had the unredacted probable cause affidavit filed in support of the charges against Mr. Allen? Yes. And was that before it was publicly available? I don't recall exactly. I do recall that he was adamant about the fact that the PCA had two versions. There was a 1.0 and a 2.0, and what we've seen, the public seen, was the 2.0 version, and that was, again, came from the same source and told him about the documents that were released in June. And did he claim that his source was an employee of Judge Gull? He did. Did he ever identify that person? He did not. Did he attribute other leaked information to that source? Yes. And what was it? He said one was more of an opinion-based. One said that this person thought that Richard Allen was guilty and hoped that Judge Gull kept him in Westville for a long time. Like I said, it was the PCA, the 2.0 version of that, the documents that were released in June. There was no reason to believe that he wasn't telling the truth because everything he was saying was right. Judge, I'm going to object at this point. I think we've gone beyond an offer of proof. We're into speculation. No, we're not. On what Mr. Baudette thought or didn't think. Sustained. Of course. Mr. McLeland says, so I don't have a problem if he wants to offer to prove. I don't have a problem if he wants to submit documents to the court as an offer of proof. But I think we've gotten outside the scope at this point, Judge. The court says, we're well beyond the offer of proof. Do you have any additional information that you wish to get from this witness? I'm sorry? Are you done with this witness? I've sustained the state's objection. No, I'm sorry. Okay. Did he identify any other sources? Did he say it again? Sorry. Did he identify any other sources? He did. Who? Prosecutor McLeland. And was he in communication with, I'm surprised he didn't object right there. And was he in communication with Mr. McLeland? He was. Mr. McLeland, Judge, again, I'm going to object. Of course you're going to object. Because you don't want stuff getting out about you. I'm surprised he didn't object sooner. I think we're outside the scope of offer to prove. So at this point, I'm going to object to the continued line of questioning. Mr. Hennessy says, the documents would establish that Mr. McLeland and Mr. Baudette were in communication. They were trading information. Mr. McLeland said he wanted to talk to other people in the group. Mr. McLeland sent Mr. Baudette a message telling him to delete everything. So that would be the testimony. And then, lastly, I'm sorry, so he and Mr. McLeland communicated, and then any other sources besides the employee of Judge Gull. Mr. McLeland says, well, Judge, I'm going to renew the same objection. I think this is outside the offer of proof of why this testimony, of why these exhibits are relevant to the hearing today. Sustained. We are done with this offer of proof, sir. Well, not really. Yes, you are. Well, but I have a right to make a record. Well, then make your record in a summary fashion, not through this witness, because you are violating any kind of offer of proof. Well, you're just having him testify to information that you want to get in the record that you can't substantiate or support. Okay, I absolutely respectfully disagree, but the only last thing I'll say is that the November 22nd of 2022 YouTube clearly establishes that Baudette had version, what he called version 2.0 of the probable cause affidavit 1 week before it was ever available to anyone. That's it. Thank you. Do you have any questions for this witness? No, Your Honor, says McLeland. The court says, all right, thank you, sir. You may step down. I recall Mr. Mullin's. Witness is sworn in. Thank you, Mr. Hennessy. All right. Questions by Mr. Hennessy. Direct examination of Mr. Mullin. Again, he's on the stand. And again, we call him Mullins, not Mullin, on accident. Hennessy calls him Mullins. You have described your function in the prosecutor's office, organizing discovery and fashioning receipts as it was given to the defense. Yes. From your duties in that regard, can you tell the court approximately how many external hard drives they were given? Sitting here today, that would be hard for me to estimate, but several, probably 20, 25, something like that. And then how many flash drives? Again, difficult for me to give a quantification here at this moment without looking at my notes, but several. Maybe I can get some clarification about your question. Was that before or after they were moved? Before and then after they were reinstated. Thank you. So before, probably maybe 15. So 15 discs, right? Are we on? Oh, flash drives. 15 flash drives, 20 something hard drives. All right. That would be before the 15 or before they were reinstated. Okay, thank you. That's all. Thumb drives. All right, that's all. Any questions? No, thank you, Your Honor. All right, thank you. You may step down. Recall First Sergeant Holeman. And I think that they got this in here on purpose so that it's in the record to state how many things they were bombarded with after the fact, after they were reinstated, and how much extra, because if you missed it, I'll put the link down in the description below as well. The defense just filed a motion for sanctions on McLeland, and they do state that they have been bombarded with unnecessary and unneeded discovery that is, I think, deliberately on purpose to hide like the actual evidence. So it takes them forever to find what they're actually looking for. It's like a needle in a haystack. They have to find the actual evidence again because everything that they had turned over, it's now given back to them in a totally different way. Once they were reinstated, all that information they had to go through again, all the discovery they had to go through again, make sure that they got everything that they had before, and make sure that they didn't find anything else that they didn't have prior to, but they've been given so much more data and flash drives and hard drives and all the things to look through, is just like terabytes and terabytes of things that they cannot go through to attorneys in a speedy trial time period. So one of the things about the sanctions is they want to get him for, needlessly sending discovery that may or may have nothing to do with the case. Basically to tie them up and bury them in paperwork or whatever, to tie them up in researching their case and to delay it. All right, so question, and then how many flash drives? Oh wait, I read that? Okay, sorry. We recall First Sergeant Holeman. Witness is sworn in. This is hopefully going to be interesting. I don't know. So Mr. Hennessy says, Judge, can Mr. Rozzi be excused? And he's okay with me proceeding. Court says that's fine. He's your client. So Mr. Rozzi excuses himself, probably because he doesn't want him to hear Sergeant Holeman's, is he a sergeant? Lieutenant Sergeant Holeman, whatever. They don't want him to hear his testimony for some reason. It may be about him. So let's see. All right, so questions by Mr. Hennessy, direct examination of Lieutenant, Sergeant, Lieutenant. I don't know what rank comes first. Tell me in the comments below because I don't know how to say it. All right, so Sergeant Holeman. This says Lieutenant and Sergeant. Can you be both? I think. All right, so Sergeant Holeman, did you obtain documents or screenshots from Mark Robert Cohen? Yes. And did he go under Funk O. Cohen 87? I believe so. I'm going to hand you what's marked as Exhibit R and ask if you recognize it. I don't think I've seen these before. All right, well, do you recognize it as Cohen? Again, I don't know if he went by Funk O. Cohen 87 or not, but didn't he just say? I believe so. Now he's saying, I don't know if he did or not. But I have to check my notes or re-interview him to see if that's actually him. Okay, well then, did you, in talking to Mr. Cohen or reviewing his material, it's your belief that Mr. Cohen received pictures from Mr. Fortson and then Mr. Cohen put them on the internet. Is that correct? No. Okay, what did Mr. Cohen do? He sent them to Ms. Kane and Kevin. I can't say her name. I don't know how to, I just can't. All right, so Ms. Kane and Kevin Greenlee are of the Murder Sheet podcast. Okay, did he, Holeman, no, who are we talking about? Cohen. Sorry, did Cohen, ever tell you that he had also, or did the Murder Sheet people ever tell you that he also had photographs of clothing, shoe prints, indentations from a tripod, that kind of stuff? Indentations from a tripod, meaning they were taking photos or video of this ritualistic ceremony, sacrificial ritual, whatever. That's disgusting and so sad. All right, so that kind of stuff. No, I don't recall that. Do you know a Mike Thomas? I do. Do you know if Mr. Cohen ever told anyone he had screen photos and notes from Mike Thomas? No. Who is Mike Thomas? Mike Thomas was the chief deputy at the time for Carroll County. I'll withdraw R. Do I need to leave that with the reporter? The court says no. If you're withdrawing it, I'll just show it's withdrawn. Any cross, Mr.? I'm sorry. Are you done with him? No. I gotta find a file. Okay, hold on. Question. You testified earlier that one of the people you interviewed referenced the leak of the probable cause affidavit for the search of Mr. Logan's property? Yes. And you testified that this person said they got it from Mr. Logan? In my deposition, I testified to that, yes. Have you been involved in the execution of search warrants? I have. How many? A lot? Yes. Have you ever left a copy of the affidavit? No. You've always left a copy of the actual search warrant? Yes. But never the affidavit? Correct. And can you identify, are you familiar with the affidavit for that search? I am. And is State's Exhibit 5 a copy of that? Yes, it is. Excuse me, yes. And then, did you ever explore or investigate why on this copy murder sheet is stamped? So, Exhibit 5 has the kind of like criminality. Sorry, I forgot to thank them. Thank you, criminality, for purchasing the transcript from this hearing and making it available for all of us to enjoy this craziness. So this exhibit, which was the probable cause affidavit, has the Murder Sheet podcast stamped in like a watermark in the back too, just like this document. If I scroll out or zoom out, you can see it says criminality. So the watermark there. That's what this exhibit has, apparently. How big did I have it before? I don't remember. Nope, that's going to be way too big. All right, that's perfect. All right. All All right, so Mr. McLeland says, Judge, I'm going to object at this point. I thought he was going a different direction. I don't think this has any relevance to what we're here to discuss today, Judge. I was giving him a little leeway, but I don't know where he's going and if it's relevant to what we're discussing today. How's it relevant? I'm sorry? How is it relevant? Well, it's relevant. One, they've opened the door because they didn't object when he testified about the Logan affidavit leak. And so that's already in, and I'm following up on it. And it goes to the extent of his investigation of this leak and his choice not to do further investigations or investigations of other leaks. And he also testified talking to Ms. Kane and Mr. Greenlee. Is it Greenlee, yes. Mr. Hennessy continues, who are the murder sheet people, so he talked about how he talked to them, what they gave him, and this is another document that has their little podcast thing stamped on it. Well, to the extent that the state inquired, I'll allow it. Woo! We got number 6 win, we gotta win, this is the 6th. We're all excited that we gotta win. Finally, Judge Gull gave us a win on this document. We're quite far in. All right, so to the extent she'll allow it. Okay, move to admit. Same objection, Judge. All right, I'll show S is it's not, admitted over objection. Let's all, Mr. Hennessy continues his questioning, or no. Mr. Hennessy says, that's all I have for Mr. Holeman at this time. Sorry. The court says, any cross? No, Your Honor. All right. Thank you, Sergeant. You may step down. You ready? The court says, you may call your next witness. We call Mr. Brad Rozzi, witness this morning. And this is one of the attorneys that is fighting these charges, or it's not charges, it's allegations, I guess, of contempt. So Brad Rozzi and Andrew Baldwin are the subjects of this contempt hearing, and it's going to be interesting to see what Brad has to say. So let's dive in. All right, so questions by Mr. Hennessy, direct examination of Bradley Rozzi. Please state and spell your name. Bradley Anthony Rozzi, last name, he spells it. How many different ways is that pronounced? I don't want to get into that conversation. We'll be here all day, okay? The press release, what day was that? The day that, are you asking about the date it was issued? Yes, I believe it was December 1st. The day there's a lot of dates running through my head, but I believe it was December 1st. Was there an order in place before that time? No, there was not, no. Were there conversations with the court about not intending to try the case in public? There were, yes. Was the press release an attempt to do that? It was not, no. What was its primary purpose? Well, first of all, it's something that was certainly thought out. It wasn't some, kind of random act that just occurred. There's a lot of strategy that comes with things of that nature. And, in my opinion, I think really the first purpose that it served from my point of view is that it communicates to your client that you're behind them, that you're behind them in terms of the endeavor that's ahead in a case like this. So lawyers that are trial lawyers that know what they're doing, that are well trained, will tell you that, getting the client's trust and credibility is important. And so I think that's one of the reasons why, at least in my mind, that I thought it was a good idea. The second reason is maybe more unique to this case. You've got, from the very day that I entered an appearance in this case, I'm getting emails and phone calls. The office is inundated with those kinds of things from third parties, from media sources. I mean, I can remember getting calls from NBC, from Rolling Stone magazine, from publications out of London. And at some point, Andy and I talked and just thought, hey, one of the things we can do is issue a press release so everybody knows kind of where we're coming from. And maybe we'll quell some of that, kind of put some of that to rest. So they're trying to quash all the media coming at them by giving the press a blanket statement saying this is the case, we don't have to repeat ourselves now. And there's nothing wrong with that, and so many lawyers do this as a strategy. So I don't know why this is even a question, but because this is Judge Gull's courtroom, we're questioning why one would send out a press release saying, I believe my client is innocent and we're going to prove it in trial. What's wrong with that? So I'm actually going to go over, because I have not gone over the PCA on this channel before, so I'm going to go over the PCA and I'm going to go over the press release in a separate video. And if I can, I might go over the Logan affidavit. That might be interesting too. If I can find the Logan affidavit, I'll throw that one in there. So anyways, stay tuned on my channel for that. Make sure that you are subscribed so that you don't miss out on DELPHI videos. I feel like I do a bajillion DELPHI videos a week. Anyways, all right. So he wanted to, the point was they wanted to put all of the media questions to bed by saying, here's the facts that we have for you at this time, and that's all we can say about it. And moving on. All right, so so that's why we did it. At least that's why I thought we did it. One purpose was to stop random inquiries, correct? Yes. Another thought was to do it in a manner where you wouldn't be subjected to questions. Oh, clearly. Yeah, sure. And then you were I'm going to approach and hand you defendant's Exhibit T. Is that me? What? Where's my phone ringing? I didn't even know my volume was on. Sorry, guys. Where was I? I'm going to approach and hand you defendant's Exhibit T. Were you familiar with the extent when you were appointed? I'm going to say late October of 2022, estimating. And were you familiar then with the extent of state agent-sponsored media presence and publications and press conferences and press releases? May I review this? Yes, you may. The state's defendant exhibit. Yes, I was generally familiar that a lot of these things were going on. To sit here and say that I knew about every one of them would not be accurate. Is Defense T a summary of the dates and the communications from state-sponsored people? That's what it appears to be. What'd you say? That's what it appears to be. Oh, move to admit. McLeland, no objection. Judge, wow. Finally. I'm not calling that a win. I mean, it's a win for us from McLeland, but who cares about McLeland? It's Judge Gull who makes all the final rulings that matter. All right, so the court, all right, I'll show T is admitted without objection. Question. What then was the press release an attempt to influence the public? Was the press release an attempt to influence the public? No, sir. Was it a plea for tips? I'm sorry, what was the question? A plea for tips from the public, information from the public. Well, I think that we were aware that that could be one of the, side effects, or I should say the result of that. I don't know that we sat and had any real discussions about that in great detail. Did, in fact, you get some tips? Did we get some tips? Yes. Oh, yes, certainly. Were any of them of value? Oh, very much so, yes. And did you know that the Indiana State Police, sometimes with the prosecutor's office, sometimes without, had a constant presence in the 5 years since the discovery of the bodies, issuing statements and revealing a little bit of information, asking for tips from the public? I am aware of that. So what is the thing that he did is no different than what the police do. On a daily basis, they go out and give press releases about what they call facts of the evidence of the case, and that's what influences society. So you arrest someone like Richard Allen, you arrest someone like Brian Kohberger in these high profile cases, and you keep everything hush hush except what the police are saying. So the police are saying, well, we know there's a vehicle that's a white Hyundai Elantra and da 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 da. So that's what the public says or hears. So obviously, you know, as soon as Brian Kohberger is arrested and you hear like, oh, well, we've got video of him, blah, 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 because the media likes to flip everything around and put things out before sources are ever even verified. Finally, you know, the first 5 minutes of what mass media will tell you when someone is arrested, you'll take that and go, oh, yeah, I could see this person's guilty. And that's what the rest of society does. Nobody goes and follows up and checks up on these things usually, unless you're a true crime junkie like all of us. But most people don't in society will take the media as, yep, they're guilty. Okay. I already have assigned guilt to them in my mind. They don't have to prove anything to me. They're guilty. When it is exactly the state's burden to prove that someone is guilty. So, anyways. All right, so I am aware of that. So what happened was Mr. Hennessy says, I'm sorry, there was a question before him. The court says, you're asking me the question, sir? Mr. Hennessy says, yeah, I got interrupted. Did you have anything to do with the email to Woodson? Mr. Woodhouse? Woodhouse. He keeps calling him Woodson. I like it. It's funny. I think Mr. Hennessy's funny. All right. I did not. Well, I did not have anything to do with the initial email. I clearly had something to do with reporting it when I learned about it in March of 2023. Did you get emails from Mr. Baldwin the day Mr. Westerman had, or no? Did you get an email from, strike that. With regard to Woodhouse email, were both you and both you and Mr. Baldwin fully cooperative and truthful to the court as that was discussed? Yes. With the Westerman leak, did Mr. Baldwin advise you that the very day that Mr. Westerman confessed to him what he had done without permission? Mr. Baldwin, Andy, called me on the day that I believe that he learned of that and basically reported that to me. And yes, we followed up and decided we were going to call the prosecutor and the judge. Was that reported immediately to the prosecution and the court? Yes, after I learned of it. What did you say? It was reported immediately after I learned of it for sure. Well, right, but you learned of it the day Andy learned of it. I believe that's true, yes. Well, you reviewed during the break the state's exhibit of the 5 pictures. Yes, I had a chance to look at it during the lunch recess. And were you present for Mr. Holeman's testimony that he was presented with all of these pictures at deposition? Sorry, could you ask that again? Sure. Man, what is wrong with this courtroom? Get a better audio. The mic system must not have been on or working or something. All right, it's a little hard to hear and we've got a computer behind us. All right, so you want my hearing device they've been giving me? Keep trying to give them a hearing device. No, it's fine. I can't really see you that well. Just go ahead and ask the questions again. Were you here when Sergeant Holeman testified those 5 pictures had been presented to him at a deposition at which you and Mr. Baldwin were present? I was here, yes. And over break, did you go back and contact the court reporter and get all exhibits that were presented to Sergeant Holeman at that deposition? I did, yes. Were all 5 of those pictures presented to Mr. Holeman, or to Sergeant Holeman? No, they were not. Which ones were not? Can I see the exhibit? Strike that. It's under seal. Well, no, he's described what exhibit I think states 6. I'm going to hand 5. I'm going to hand you states 5, which has been admitted over objection. Can you please go through there and describe generally which photographs were not presented to Sergeant Holeman? Photographs 3 and photographs 4. I'm going to talk about the details. Well, neither have, I'm not going to talk about the details. And he says, well, neither have they. But 3 or 4 is not helpful. So there's a picture, and they've already said one of the victims that has blackout marks, including a dash and a circle. 4. Could you find that one? That's the 4th page? Okay. This is confusing. Of this 5-page exhibit. Was that presented to Sergeant Holeman? It was not. Is that something the defense ever prepared? No, not. I haven't, and I don't believe Mr. Baldwin has, because I was part of those depositions and I haven't seen this. So you've never seen that photo before? I have not. And to your knowledge, that picture was never given to the defense? No, I just looked through the exhibits when I was at lunch, and this is not one of them. So he just literally looked through the exhibits at lunch. Wasn't given to Sergeant Holeman. Okay, what was the other one? It would be the 3rd page on this 5-page, in the 5-page exhibit, which is a handwritten diagram. It looks like almost maybe, I don't know, pencil or crayons or something. Is that the handwritten alleged diagram of sticks and like a roughly drawn person with sticks placed around them, or did that? Yes, sir. Yes, that's a fair description. Have you ever seen that before? No, I've never seen this. Was that ever presented to Sergeant Holeman at the deposition? It was not attached to the exhibits, and I looked at. Sorry, let me slow down. I get excited and I read fast, and then it was not attached to the exhibits that I looked at that were given to us by the court reporter, and I believe it was absolutely not. Mr. McLeland says, Judge, I want to make a point of clarification. I think Mr. Hennessy has mischaracterized Mr. Holeman's testimony. I had to look back at my notes. What I remember Mr. Holeman saying is some of the photos were from the deposition, not all of them. So that's my recollection of the testimony from Mr. Holeman. So I wanted to clarify that for the judge. Okay. Mr. Hennessy says, the record will speak for itself, and I guarantee he described the circle part because I wrote that down in my notes with question marks, wondering what he was talking about, and then it came out later what he was talking about. Question. Were you present at any unrecorded conference in chambers where the protective order was discussed? What'd you say? It was the gag order. I think that's what you're talking about. Okay. And yes, I was present. And what was that discussion? The basic discussion was that Mr. McLeland, myself, Mr. Baldwin was there. I believe, I'm pretty certain former White County prosecutor Robert Guy was present at the particular conference. I know it took place in DELPHI, and I remember the discussion was prompted by I love how he's being so descriptive, because that's how you make a foundation. He knows that. So he's like, I'm putting this all in and it's getting in there. Why is this wet? It's driving me nuts. I'm going to set it aside for now. All right. I remember the discussion was prompted by the lawyers communicating to the court that he felt kind of handcuffed because we had the orders in place and we didn't really know who we could talk to. Could you even talk to, a potential witness? Could you share any information with them, to try to determine their credibility or to corroborate information they were giving you, those kinds of things? I mean, I feel like even the prosecutor, communicated that it was kind of an odd space that we were working in, and we just didn't really know where the fog lines were, so to speak, on the road, and the judge was kind enough, frankly, to have a discussion with us and try to define, where those lines were. And, my recollection of the conversation is basically, Your Honor told us that, this is primarily intended to keep us from releasing information to media outlets, to having press conferences, to doing what I would consider kind of more traditional media type relations, if you were, I guess, in a case like this. And so that was the nature of the conversation we had. Was it expressly discussed that you could discuss evidence and discovery that you'd received with people you wanted to consult with for trial preparation? I'd say that was the exact discussion we had. I think it was more along the lines of, if it's not media, then it's okay. Did you watch Barbara McDonald's report on Court TV? I did. In watching that, did you notice stuff that she had that could not possibly have come from the defense? Mr. McLeland says, objection, Judge. I don't see what the relevance of that is to the hearing. How is it not relevant? The court says, how's it relevant to the hearing, sir? Mr. Hennessy says, well, it's the same response as before, but on this one, I'm adding it could not possibly come from the defense, which is, it goes directly to the issue of what defense did provide, what defense did and didn't provide, and he's prepared to testify he saw her with stuff that he could not have possibly come from the defense, and he's testifying on his own behalf. Overruled. Is that another win for us? Are we on 7 now? Holy cow, she overruled it. Do you want the question again? I saw her, holding what I could consider part of a report and talking about it openly, and it's certainly something that I knew was part of the discovery, and it wasn't provided by me, and I'm fairly certain it wasn't provided by Mr. Baldwin. Because both of us were pretty surprised that she was talking about this openly, to the entire viewing public. And wasn't there something about sticks? Well, it was the Purdue report, is what it was. Wow. So Court TV had a copy of the Purdue report. Yet they couldn't even turn it over to the defense as discovery in time. All right. Okay, and I'm not going to... Oh, wait, sorry. And I'm not sure... I'm not sure we had it at that point. I could be wrong. But if we did have it... So defense didn't... It may not have even had it at the point. But if we did have it, it was just right close in time. But I actually don't think that we even had it. I think that later, when I saw the report, then it was brought to my attention that there was this broadcast, and I watched the broadcast, and it was the report that I had just gotten, and I actually shared that with the court just for context. I'm going to approach you and hand you an envelope that is marked flash drive, Barbara McDonald, interview on Court TV. Do you recognize that? I do. And was that preserved on a flash drive? Yes. Look inside. Tell me if that's a flash drive. Yes. Thank you. Mr. Hennessy, move to offer Barbara McDonald on Court TV. Defendants Exhibit U. Mr. McLeland says, Judge, same objection to relevance, and also I believe it's hearsay. I haven't watched the report, but if it's going to be her testifying about what she's gotten and what she believes is leaked, I think that applies to hearsay. Any response? Same response. All right, I will show you that U is not admitted as hearsay. Well, she let in the testimony, but not the, she let in the testimony about it, but not the exhibit itself. Question, are you familiar with the Indiana Public Defender Council's performance guidelines? Generally, I am, yes. And have you lived up to them? Yes. And is brainstorming and war rooms for trial prep common within criminal defense counsel and considered essential to trial preparation and adequate representation? It is. And then you are familiar with the Indiana State Police typical protocol for investigations such as the one at issue here? I actually do have some knowledge of their general protocols, yes. And how do you have that? Because I've represented state troopers that have been accused of crimes. I have a brother who's one of the chief detectives at the Peru Post, and I talk to him routinely. I'm very familiar with what goes on in the state police. Investigative ranks, so to speak, and a lot of friends and a lot of other clients that work in the field. Okay, what would be their normal protocol for an investigation of leaks by defense counsel in a criminal case in which they were involved? Well, I've never been involved in a case where there was an allegation of a defense counsel leak, but I've certainly been involved in cases where there were, let's say, ethical issues at stake, and they typically farm those out to other posts. In fact, I had a meeting with one of their, I think they call them their internal investigative unit or whatever. I actually had a meeting a week or two ago with a client with an internal officer, and so they're typically farmed out to other posts so that there's some separation of the activities, some independence. Thank you. Without getting into them, are you familiar with, from your review of all the discovery provided on this issue, that they've given us over 100 pages of Fortson stuff? They've given us Westerman stuff, Cohen stuff. Are you aware of any of other leaks that cannot possibly be connected to the defense? Objection, judge, relevance, just in general. We're not going to get into it, but whether he was aware of it. The court says, I think you made your point, Mr. Hennessy. I'll sustain the objection. Oh, did both you and Andy, it's in evidence, you wrote a letter to Judge Gull. The state introduced that into evidence. Okay. You recall that regarding the Westerman situation? I can't remember. Yeah, I know. I wrote a letter to her in the fall. I'm not sure. I might have written more than one. So, question. Are you positive that you and Andy cooperated fully with candor and honesty to all inquiries by the court regarding anything at issue here? Yeah, I sat down with Officer Rector and signed an advisement of rights and answered every question that he asked me immediately after we heard of all of this. That wasn't the question. The question was, with the court, any questions asked by the court, did you respond? It's Rule 3.3 of the Indiana Rules of Professional Conduct. Respond, candor versus the tribunal. It only applies to when the court asks questions. Did you and Andy respond with full candor, honesty, cooperation to any question from the court about anything at issue here? Yes, sir. That's all I have. Mr. McLeland, thank you, Judge. Cross-examination of Brad Rozzi by Prosecutor McLeland. Mr. Rozzi, I think you said this, but I want to make sure I'm clear. I want to start back in the beginning with the press release. You concede that there was an in-chambers meeting before you and Mr. Baldwin made the press release where you told the court, Judge, there's no reason to issue a gag order. We're not about trying this case in the public, or something to that effect. I think it was not that. There was a discussion in chambers, generally speaking, which I frankly think you prompted, about trying the case in public. I do acknowledge that. Love that he threw it back in his face. You brought it up. Question. And in that meeting, you said, Judge, there's no need. We don't consent to the gag order, but there's no need for the gag order. Do you recall that? I think that's a fair summary of the conversation we had. And then after that is when you agree that after that is when the press release was put out by you and Mr. Baldwin. Yes, sir. Okay, the email that Mr. Baldwin sent to Mr. Woodhouse, when did you find out about that? I found out about it on the day that we reported it, which I think was some day in March. I think what I later learned was that it occurred maybe in December, and frankly, I've already forgotten the date on that, but I found out about it in March and then reported it immediately thereafter. And do you know, was the email sent before or after the gag order was put in place by this court? I don't, Mr. McLeland, I really don't know. I'd have to look at the dates. And do you agree that perhaps not all, but some of the photos that were leaked by Mr. Westerman are photos that the defense created from discovery provided by the state? Well, I don't know exactly what Mr. Westerman did. I wouldn't know Mr. Westerman if he were sitting in his chair, this chair next to me. Okay, so I don't know what he did. Good answer. So the answer is the answer is no, I don't know. Okay. The photo that you saw today and State's Exhibit, some of those were those created by defense, specifically the side-by-side photos. Those look familiar to me from the deposition of Mr. Holeman from early August. They do look familiar. I mean, of course, they're kind of screenshots of screenshots, so it's kind of hard for me to sit here and say that's exactly the document that we prepared. I'm not trying to get overly technical, but they might have been reproduced. Okay, so I guess what your answer is, you don't know, or I'm not really positive. Okay, I don't know. Okay. I don't have any other questions, Judge. Thank you. Mr. Hennessy, can I have a minute? Sure. No redirect. All right. Thank you, Mr. Rozzi. You may step down. Thank you. You may call your next witness. I have no other evidence on behalf of Mr. Baldwin and Mr. Rozzi. The court says any rebuttal. Mr. McLeland says, I'm sorry, Judge. The court says any rebuttal evidence. Mr. McLeland says, no, Your Honor. Thank you. Because all the evidence from the defense was not admitted, so what do they have to rebut? All right, so no. Any argument you'd like to make, Mr. McLeland? Judge, I'd just like to briefly, I'll just try to keep it short. Sure, go ahead. I understand we've taken a lot of the day. But, Judge, this is a unique situation. I can honestly say I've never been in a situation where we've had to handle this kind of issue. From the state's perspective, this started in our first in-chambers meeting back in November of 2022. My recollection of that is that we had an in-chambers meeting and I had the gag motion in hand and defense said there's no need for that. We're not about to trying this in public. And then, just a few short days later, the press release is issued. The court issued the gag order in response to that press release. Again, the state's belief is that from the evidence that was an attempt by the defense to again try this in the public and push their narrative of this case out to the public. Ooh, they're so bad. Trying to dispel all the bad press that the prosecution has done to the defense. How dare they? How dare they speak up for themselves? We've addressed that. We've moved on. Then we move on to the email sent to Mr. Baldwin. The state does believe the gag order was in place when the email was sent. The court can take a look at the documents that we submitted under judicial notice, and they show the email was sent in late December after the gag order was sent. I think it's in violation for a misdirected email. I think it's in violation of the gag order. No, it's a simple, honest mistake, and he asked the guy to delete it, and no harm, no foul. Like, I don't understand. What's the harm done by this? What is the harm done? I don't get it. All right, so I think it's in violation of the gag order because it disseminates information, specifically witness names, to one person and what evidence exists in the case out to the public. Mr. Baldwin said that he contacted Mr. Woodhouse and had him delete it and didn't come forward and tell the court until the state found it in March of 2023. And so I think there was a violation of the gag order that both parties failed to report. And I think there was a violation of the gag order that both parties... Oh, sorry. I just reread the same line. That they failed to report. And I think that is something for the court to consider as well. And then they didn't need to report it. There's no requirement for them to have done so. And then we get to the most egregious, Judge. In the state's mind is the leak of the photos. We got notice. The state got notice in the beginning of October that there was a leak. We began an investigation. There were several emails I submitted to the court where the defense says the leak's not from us. We've had all our people sign NDAs. We think it's from law enforcement. We start to track down the leak, and as we get closer and closer to the source of the leak, Mr. Baldwin and Mr. Rozzi come forward and say, we know who the leaker is. We'll tell you it's Mr. Westerman. He broke into my office and took some pictures and leaked them. And now this page is going to be hard to read because of the way it was photocopied. I think Mr. Hennessy used the word snookered. It wasn't our fault. We didn't know he was doing it. That's where the leak came from. As we continued to investigate, we pulled documents from Fortson's Facebook page. I think it's clear from the Facebook messages that the leak was not just the pictures, it was ongoing. Mr. Fortson has information privy to only the defense when Mr. Baldwin's coming up to Fort Wayne to drop off exhibits and when he's meeting with Mr. Rozzi when the information about the Purdue professor came out. Information about the girls' cell phones. So all the information shows a continuing leak by the defense to Mr. Fortson. We don't get to question, we don't get an opportunity to have Mr. Fortson here today because in the midst of this investigation, he self-deleted. And the information that we have is that at least part of his reasoning is that he was concerned about the investigation and the facts of this case. So we proceed forward with the investigation. We interview Mr. Baldwin and Mr. Rozzi, and Mr. Baldwin changes this story a little bit from what he told the court and the state on October 10th. He now says Mr. Westerman is a consultant and that he's given him the Franks motion. He consulted with him about the DELPHI evidence. That's his information that he gives Detective Rector when he interviews him. And so his story's changed a little bit. In the meantime, Mr. Westerman files an affidavit with the court, and the court has that. Mr. Rozzi writes a letter to the court. The court has that information as well. And then we get to the search of Mr. Westerman's iCloud account, and we find out that Mr. Baldwin's talking directly to Mr. Westerman and releasing evidence, stuff about the crime scene, what the victims are wearing at the crime scene. And the ironic part is now Mr. Westerman apparently has turned into an employee of Mr. Baldwin because they made the objection to those messages are now work product. All right. That was it wasn't hard to read, but I'm glad we're through it. All right, it's hard on my eyes. Mr. Hennessy says, now I'm going to object to that. Objections aren't evidence, and that's been clear and been the law forever. And in fact, I objected can't be laid at the feet of Mr. Baldwin, the client, and the objection was work product based upon the mental impressions of Baldwin. It didn't go to the Westerman stuff, so no. That is not making Westerman an employee. I object to the form of the argument. Overruled. And so it seems that Mr. Baldwin wasn't entirely honest with the court on the October 10th phone call. And it seems, as we've gathered more information as we dig deeper into the investigation, again, we show an ongoing leak where the evidence could only have come from the defense, and it shows an ongoing leak. How many times is he going to say that? Ongoing leak. Which he just has to keep reiterating that because he's just trying to defame these poor defense attorneys. And it's sickening that most of society hates defense attorneys for no apparent reason. They actually, when your rights are violated, you're going to want a defense attorney. They're the ones that stick up for your rights. They are the only ones that stick up for your rights. The state wants to prosecute. The state wants to put bad guys behind bars. And the defense wants to preserve your constitutional rights. And that's just what it is. All right. Anyways, Mr. McLeland, so it seems that Mr. Baldwin wasn't entirely honest with the court on the October 10th call, and it seems, ongoing leak, and it appears from Mr. Fortson's message that the goal of that was to push this narrative out to the community or out to the public to gauge their response. We even heard an attorney testify he does that with his sisters, so it's not completely outside the realm to think defense was doing this purposefully and intentionally. And so, Judge, given all those things, we believe the information, the state has proven the information outlined, and contemptuous information has been proven. It's not up to the state to recommend sanctions, in my opinion. That's left to the court. What the state wants is just to be able to move forward with this trial and make sure that everyone has an equal opportunity at trial, not only Mr. Allen, but also the state. And I guess I'll leave you with this, Judge. if the shoe were on the other foot and I had leaked those photos, you leaked photos, you leaked information to Fig Solves, apparently. How are we just going to ignore that fact, but we're going to focus just on the defense attorneys and their seemingly misconduct when it's not? You're just twisting what they did. All right, if I had leaked those photos to a friend of mine had leaked those photos, I can guarantee the defense would be screaming from the mountaintops not only to have me removed from the case, but disbarred. You might have actually done some of the leaks, Nick. I don't know. He might have done some of these leaks of photos and whatnot. So look at how they've attacked me personally already in all of their filings. And so I think you're being attacked because of what you're doing to them, not because they're trying to attack you personally. It's because of your actions and behaviors, Nick. And so I don't think it would be it would be a totally different story if this was a leak committed by the state. The defense wants you to believe that, oh, it's not a big deal. It wasn't our fault. It doesn't matter. It doesn't matter, Judge. It does. These are intimate photos of the crime scene that are leaked to the internet, and we still don't know if we have them all. We never will. Like, why are you outraged about this? There are still crime scene photos from crimes of, all over the century. Like, why does this matter so much to you? Why is it so important to you that there are photo leaks and you have to pin it on the defense who did it? I really think Nick had something to do with the photo leaks. I really think he did. He might have been the source of the majority of these leaks. And turning it around, trying to pin it on the defense, and I think that's sickening. And I think that's what he's doing. If not all of the leaks, at least some. All right. So it matters. These are intimate photos. And so the families have to risk every day when they get on the internet, risk opening a page or getting an email from somebody or getting a communication from somebody that has these photos attached, and that's the real damage. It opened the public, the potential jury pool, and everybody in the community up to evidence that's only presented at trial. It's going to be public once it hits the trial anyways. So what does it matter? And so, given these reasons, Judge, I think the state's proven that the information in the contemptuous information has been presented to the court. Thank you. And the court says, Mr. Hennessy, well, the hyperbole at the end has no foundation in the evidence. We don't know if they're still out there. We don't know if we have them all. The family has to live in fear. Yet, Mr. Holeman, Sergeant Holeman, when I'm asking him, there are people reporting that other people have the photographs, but he didn't go investigate them. He didn't go try to get them. So if they're still out there, it's because they didn't do their job to go get them. All after a leak that cannot be willful on the part of Mr. Baldwin and Mr. Rozzi not even being involved with it. The press release, there's a case that says contempt isn't used to correct it if you offend sensibilities of the prosecution or the court. Yeah, so if you're offending my sensibilities, like, how dare you release this photo or leak this photo, that's basically what they're doing here. And it's like, well, there's no law against that. It's not a law that they're breaking necessarily. Even if they didn't do it, but even if they did do it willfully, it's not like they're breaking the law. I don't think. There was nothing. I mean, unless they're sealed, obviously, and he's going against a court's order and they're sealed, but they're going to be made public anyways. It's not the end of the world that these photos have been leaked, honestly. I mean, it is something that a defendant or defense attorneys would never want out there in the first place. So why would they leak it? They don't want that prejudicing their client, because you see that and you become emotional. You have emotions about it. So you're going to tie the person who they have in handcuffs to that crime because you want someone to go down for it. And that's what they're doing. But anyways, sorry. So the press release There's a case that says contempt isn't used to correct if you feel offended by the prosecution or the court. If you feel offended by me, then you don't get to come at me for contempt just because your feelings are hurt or you're offended. I get what they've said. In their mind, the press release had a legitimate purpose of not trying the case in the public. The state did the same thing, only much longer and much more detailed, by giving tips to law enforcement and using law enforcement to put out their narrative. They did get tips, and it helped the defense of Mr. Allen. It did not persuade the public because the case has been on fire from day one, and you've had two camps and they fight each other. They got in a fight out there, and they go back and forth. They speculate. They get leaks they make leaks. So, no, that did not influence the public. The email to Woodhouse, and I apologize if there's a Mr. Woodson anywhere for continuing to butcher his name. How does that violate the gag order? The gag order says public dissemination. It's an accident. It happened to everybody, or it happens to everybody. And you had 3 extremely experienced lawyers testify that they did exactly what Mr. Baldwin did. The evidence is, and it's in Sergeant Holeman's report, that within an hour, as soon as he discovered it, he contacted Woodson, Woodhouse, told him to delete it. It would never cross my mind to report that to anybody because I would consider it cured. So, 1, it wasn't to the public, it wasn't to the media, it wasn't public dissemination, it was a mistake, an accident. With regard to the photos, they kept trying to connect Fortson to Baldwin. There is no evidence in my cross-examination, I can't remember who it was, might have been Detective Rector, whoever was talking about the Fortson thing. There was only one reference to Andy, and it was not I talked to Andy, this was from Baldwin. You do have Andy and the rest of the evidence about Westerman from his 2-hour interview and other communications to the police and prosecutor and court is that Westerman has a law degree, but he is not an attorney. He is considered by Mr. Baldwin and other lawyers to be highly skilled strategist. Many people consult him for trial preparation. It was concluded, I think, and Mr. Rozzi testified that that was a function that was permitted by the gag order. Mr. Fortson is only connected to Mr. Westerman, and they should have produced Mr. Westerman and Fortson clearly had other sources, so there's no direct connection from Fortson to the defense, so their whole theory of a continuing leak to the public is not founded. What they were talking about was between Fortson and I want to say Cohen, discussions between them, but everything they pointed to, the Frank's memo, everything referenced in that series that they went through never appeared in the public arena. It was never went on a podcast. That was only some of the photographs that Mr. Westerman took. And again, how can that be willful if you take something from me? You've got to know something about it for it to be willful, and there's no connection to that. There just isn't. I won't repeat the law on the burden. I would ask that you look at my memorandum that I filed in advance of today. Trial courts don't have jurisdiction to enforce the rules of professional conduct. To the extent any of this should receive review upon a complaint to the disciplinary commission, that's a separate issue because this is a criminal contempt proceeding. The trial courts don't have the jurisdiction to do that. And then lastly, I'm going to ask, now that the evidence is all in, if I could do a subsequent memorandum since you granted specific findings of fact and conclusions of law. I thought perhaps we'd have time before you rendered a decision. So if there is time and you're going to take some time, I would like to do a post-hearing memo. Thank you. Any final thoughts, McLeland? No, Your Honor, thank you. So how much time do you want for a post-hearing memorandum? I could probably get it done in a week. And then will the state ask for time to respond to that? Judge, yes, just because I'm not sure what he's going to put in there, so I better have time to look at it. If I could have a week after to respond, Judge, that would be sufficient. So I'll give you, Mr. Hennessy, until March 25th to file a brief. The state will have until April 1st. And then the court could make its 30 days to rule. So that puts the week prior to the trial. Is there anything else from the state on the contempt information? So she's not going to rule in this contempt hearing until the week prior to the trial, which is in May something. My dates are all flubbed because of we're going back and forth from multiple cases, but yeah, and we have a May something date. Was it the 12th or something? I don't know, something around there. All right, so all right, anything from the defense? No, ma'am. All right, it's just a little bit over 3 weeks, 3 o'clock. I would like to still do the motion to dismiss that was filed by the defense. Why don't we take a break? We've been sitting here for a couple hours. that ends that hearing, and then this is the certificate that it's official from this reporter here, Jody Williams. All right, so that was the end of the motion from May 18th with David Hennessy and Nick McLeland discussing contempt, having contempt allegations against Baldwin and Rozzi. So we also did the motion to discuss. So if you are interested in the motion to dismiss, not discuss. The motion to dismiss the charges. So it was a filing that the defense did. They want the charges dismissed, and they wanted a hearing on it. So it's an argument on that, and it's much shorter than this, and I have it in one part, so you can watch it. Also, it'll be in the description below. So let me know what you guys think now that we've gone through the entire transcript and listened to all of Judge Cole's rulings. At this point in time, can you possibly at any point say that Judge Gull is playing on the up and up? That she's playing, with everybody with a full deck? No. She's giving the prosecution the full deck and then some cards, hiding them up her sleeve, her big giant robe. And she's taking them. She's taking those cards. She's taking away any chance she gets. She's taking cards away from the defense in order to defend themselves. And it's very disheartening to see that this is going on in our court of law still to this day. And we're supposed to have transparency. And there were no cameras in here, I'm sure, for a reason, because Judge Gull didn't want us looking at how bad she looks. She didn't want us to see her bias, even though we've already seen it. But I mean, it's blatant. If you have read through all of this and still don't think that she is biased, let me know in the comments below. I want to hear from you. Why? Why do you think she's not biased? And prove to me that she isn't. Because just like prove to you that Richard Allen is innocent, prove to me that Judge Gull is biased. And that's what I ask from my followers or whoever's watching this and still believes that Judge Gull is the right person for this job. I don't think she should be a judge, period. Because when you're showing this much bias, you're done. You shouldn't be there. That's my opinion, and I am sticking to it. And I'm sorry if you disagree. Let me know in the comments below why you disagree, and let me know why that is. Just give me a reason, All right. And I'm open for discussion. It's critical thinking and analysis and discussion, and no name calling. If you name call on my channel or insult people, you get blocked. No questions asked. I report and block you. That's what I do. Because I want to keep it classy here. Like Attorney Melanie Little says, keep it classy. I want to keep this civilized because so many people get so heated and passionate about these things. And I do too. I get heated and passionate, but I'm not going to say, no, you're wrong. You suck. Boo. I hate you and your side. I'm never going to do that. I'm going to be like, well, tell me why. I'll listen. I'll believe still what I believe, and I will probably not change my mind unless you really have some compelling evidence that shows me something that is against what I'm thinking. But anyways, yeah, it's interesting. This whole case is interesting, and the injustice that is being done for the girls, the injustice that is being done with Richard Allen and his family, his wife, without him for the past 18 months or whatever it's been, 16, something like that. And she's missing his companionship, his everything, just him being around, but also his financial, his ability to contribute financially to her household and, be there, be a parent for their child. I believe they have a daughter. So, I mean, it's just, he is a victim too. There is no justice if the wrong person is sitting in prison for a crime. There is no justice for the victims, and there's no justice for that person in jail, because any second that is taken away from their freedom is a crime and should be redressed by the government. But unfortunately, most times when you are wrongfully arrested, wrongfully convicted, you don't have a whole lot of ability to go back and make those people that put you there accountable. And that is a huge problem in our justice system. That's the problem. We don't hold those people accountable. If prosecutors were accountable for the wrongful convictions that they put forth, maybe, just maybe, there would be a whole lot less wrongful convictions. I don't know. Just a thought from someone who's not a lawyer, but just watching this from the outside. All right. Well, on that note, I will see you guys next time. Thank you so much for watching. I appreciate you all. Please hit the like on the way out, and stay tuned for my video of the probable cause affidavit for to arrest Richard Allen and search his home, and also the press release. I'm going to read over the press release that is in question here, that is so over the top that means that the defense was trying their case in the public, which I don't think it was, but we'll get into that. So thank you so much, and I will see you in the next one. I'm out of here. Bye, guys. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.